Okay, so this is Liz Brandt, and I teach family law at U of I for a little bit longer. I'm here with Julie Kane. I'll let her introduce herself. Hello, my name's Julie Kane. I am the managing attorney for the Nez Perce tribe. So Liz and I are going to do this presentation together. So if people are on the phone, I think it will help our sound if everybody mutes their phone. And then we'll try to pause at relevant times and take questions. And then if you would identify yourself when you ask a question, that would help us all know who's who. So, and yeah, Alana, if you could get that muted, I think it would be good because we're hearing a huge echo. So I'm turning it over to Julie to get started. All right, so the first slide is up. Oh, that's better. Yeah, that was better, whatever happened, yeah. Okay, beginning in 1887, the federal government attempted to Americanize Native Americans, largely through the education of Native youth. By 1900, thousands of Native Americans were studying at almost 150 boarding schools around the United States. These boarding schools continued to operate. Actually, there's some still operating today. There's one in Salem, Oregon called Chamawa Indian School. And, you know, it's just this constant, what are we going to do with this population and how are we going to incorporate them into our society? And they tried different things. There was well, like the schools banned tribal clothing and required students to cut their hair, and they wouldn't let them speak their native languages. And there were other programs like the relocation program where young adults on reservations were provided with money for a bus ticket and for a deposit for an apartment, and then sent to these large urban areas to just go try to find work and get off the reservation. And these policies had a real impact on Indian tribes. So on the second slide, before the United States before Congress passed ICWA, there was a project called the Indian Adoption Project, and that was in the late 1950s and early 60s. And basically it was just standard practice to, if there were any Indian kids that went into care, they were adopted out, and almost never to Indian families. In fact, the statistics here are that by the time ICWA was passed in 1978, up to 35% of Indian children were removed from their homes by state child welfare and private adoption agencies. 85% of those placements were with families and communities outside the reservation. So huge, huge impact. In Minnesota, 1 in 8 children under the age of 18 was in an adoptive home. I mean, just huge, staggering numbers. And during 1971-72, nearly 1 in every 4 infants under 1 year of age was placed for adoption. The adoption rate of Indian children was 8 times that of non-Indian children, and approximately 90% of the Indian placements were in non-Indian homes nationally. So this next slide, I'll just let you guys read it. I mean, it's just heart-wrenching. So you send these kids to school, they have to cut their hair, they can't speak their language, they can't even contact their families. And then by the time they spit them out 8 years later, they don't know which side is up. You know, we're going back to the reservation, but we have no idea what we're supposed to be doing there. Just a terrible, terrible policies. So the impact of this removal on Indian people and tribes is that it's linked to substance abuse, mental and physical health issues, and the widespread nature of removal undermined family and community structures and led to a loss of parenting skills and understandings. So all those oral histories and, watch your grandmother do beadwork, this is how you get leather ready for moccasins, all of that was lost. And so today tribes have experienced a loss of language, culture, all these cultural activities that were done, that were taught to children when they were young, and their identity, as well as the disruption of the communities in general. And research now is documenting this impact of ongoing intergenerational trauma. It's called historical trauma. So with all these children being placed outside of the reservation, it was a threat to the survival of Indian tribes and their unique values and traditions. I was listening to a presentation by our cultural resource manager the other day, and he was trying to explain the idea of homeland, the word homeland. What does that mean to you? And how many people in this country can say that the land that they live on is the land that every single ancestor they have ever had lived on? I mean, homeland is a whole different concept for Indian people. And so when you leave the homeland, it's a much bigger deal. It's a huge deal. So these Indian kids that were raised in non-Indian homes and institutions experience psychological problems. You want to add something, Lynn?
No, I was just going to say, I think it's really important to kind of recognize all these issues because, the parents of kids that we're dealing with today, I think their parents and they have experienced these kinds of impacts and their understandings about what a family is, how to parent children, how their cultural group parents children, that's all been disrupted. So, you see things like this lost bird syndrome, which is something that has been identified in people kind of trying to figure out who they are, where do they fit in, feeling ashamed of being Indian, and not understanding the whole family dynamic that some of us from more stable backgrounds, even those of us from backgrounds we would consider to be unstable, haven't experienced the kind of disruption that this entailed.
Yeah, so, and like that last line, the sense of place in the extended family, I mean, just real disruptions in that. I was telling Liz earlier that our social service manager said they just had a woman show up on their door who's really needs a lot of services, and she had never been to the reservation before. She was Nez Perce. She was born in, what did I say, 1962? Yeah. So she's in her late 50s. She's one of 11 kids. Every single one of those siblings got adopted out by different families. So there's just this whole loss of and it was intergenerational. It wasn't just one generation, it was several generations. So why was ICWA passed? It was because of this huge number of kids that were being lost, and tribes were losing their soul. And so ICWA was meant to implement the congressional conclusion that federal attempts of assimilation had harmed Indian families, not helped them. It was passed to prevent unwarranted removal of children from their families and tribes. It assumed that children who were removed would maintain their affiliation with their culture and tribe. So this is the thing that ICWA does, is it keeps that connection with that cultural connection, that connection to their homeland and all that goes with that. And it provides a voice to tribes in the decision-making process regarding the children's, because what is, the very future of the tribe is based on whether their children can carry on those cultural traditions.
All right, so Julie and I have done this presentation for lots of different groups, and we always think it's really important to start out reminding ourselves why we have this statute and why Congress passed it. Talking about ICWA, I'm going to focus mainly on, because I think most people here have got the basics of ICWA, I'm going to focus mainly on things that are changed under the new regulation, the not so new regulation that became effective in December 2016 in ICWA case. So the first thing is to talk about when ICWA applies, remind ourselves about the basics. You got to have an Indian child who's a member of a federally recognized tribe or eligible for membership and is the biological child of a member. The tribe makes that determination. The big thing I want to mention with regard to this slide is that prior to the adoption of the regulations, ICWA was very ambiguous about whether it applied at the time of shelter care when an emergency removal happened. And the notice provisions of ICWA for 10 and 20-day notice didn't seem to jive with the situation involved with an emergency. And so, you know, we had here in Idaho reached a bunch of kind of agreements and compromises about how we were going to try to start complying with the Act. In large measure, what we were doing in our forms and our bench guide and our bench cards prior to the adoption of the regs is we were saying, look, you've got to try to start complying with ICWA from day one. You got to ask all the ICWA questions at the shelter care and that kind of thing. But adjudicatory is when ICWA kicks in and really applies. And that was our way of making sure that we were dealing with all the notice requirements. What the regs make clear is that an emergency removal is a separate type of proceeding governed by ICWA, but it's a separate type of proceeding from a child custody proceeding. And when you really start to dig into it, it almost reads as if you had two different court cases going on. In fact, obviously here, our state practice has merged those into one continuous case, but we need to, at the shelter care phase of the child protection case, we need to be complying with the statute and regulations with regard to emergency removals. When we get to the adjudicatory phase, that's where the child custody proceeding begins. So that's, I think, a big thing. I'll kind of come back to that when I talk about the regs, which provide a lot better guidance for us, more than guidance requirements, but a lot better information about how to handle emergency removals. A couple things on child custody proceedings that I want to point out. The regs clarify something that was a little bit under question previously, which is that juveniles who are detained away from home for status offenses under the Act, we're talking about offenses that would not be crimes if they were committed by an adult. ICWA applies to those kids. There was ambiguity under the statute and guidelines previously, and the new regulation makes it clear that ICWA kicks in if that juvenile is being detained away from home for such an offense. And then the new regulations kind of put some italics and bold type on the voluntary placements of children. So when parents are stipulating to the placement of children, we refer to these as voluntary placements, but under ICWA, they are not. Under ICWA, if the parent cannot demand the immediate return of the child, once they sign that agreement and they stipulate, then they can no longer demand the immediate return of the child. That's not a voluntary proceeding under ICWA. We all think about it as voluntary because the parent is stepping up and they're saying, you know, yeah, I got this problem and yeah, this stuff happened and yeah, we think, you know, we're agreeing to let the child be taken into care. But ICWA still doesn't treat that as a voluntary case. So you've got to be making sure that you're complying with all of the ICWA requirements there. So I'll just pause and say, are there questions at this point in time? Okay. So the next slide is looking at how the court determines which tribe is the child's tribe, and the new regs provide us with a lot better guidance on how to do this. So just kind of, this slide reiterates some of our existing practice and incorporates some of the directions from the regulation. So the tribes define citizenship. If the tribe concludes that the child is eligible for membership, the court's obligated to follow that determination. The tribe is a sovereign entity. It gets to decide who its citizens are, and we being non-tribal members in state court don't get to question the sovereign decisions that another sovereign makes on this matter. The biggest problem comes up, I think, in situations where the child is eligible for membership in more than one tribe. So the regs direct us to give deference to the tribe in which the child is already a member. So if the child is enrolled in tribe one, but they're eligible to be enrolled in tribe two, the regs direct that tribe one should be given deference in this membership. The child's already enrolled. That's a decision that the family's made, and presumably that reflects the family's sense of association and priorities, and that's why we ought to be given deference. The regs direct that the court should provide the opportunity for the tribes to determine which tribe should be designated. I think that that's important. It's a new provision in the regs, so the judge can't just kind of take the testimony at the hearing. The judge has got to at least give the two tribes the opportunity to talk to each other, or more tribes. I guess it could even be more.
Yeah, it could be more. It could be up to 8 tribes.
But,
or more even.
But to provide that opportunity as to which tribe should be designated. And then finally, the regs solve a question that was a problem for us, which is that they provide that if the tribes cannot agree as to which tribe should be designated as the child's tribe, then the court can make a decision. Some of our judges and judges across the country were very reluctant to kind of come in and make this decision. I think some judges were too easy to make it, so we just had a range of practice. And the regs give some guidance about how the judge should make the decision: the length of past domicile on or near the reservation, which tribe is the child's parent a member of, the interest shown by the tribes, previous adjudication regarding the child in the court of one of the tribes, and the child's own self-identification are all factors the court should be looking at in determining which tribe is going to be designated as the child's tribe. I think in this arena, the biggest issue for us is where the court moves too quickly in resolving conflicts over the child's tribal membership. And so we don't have the opportunity for collaboration, and we don't get enough of the facts into the case that would give the court a basis for deciding the tribal membership. So
just an example is my own situation where I'm enrolled in another tribe, but my husband is Nez Perce. So our kids could be enrolled in either my tribe or my husband's tribe. And, our decision was that we wanted to enroll them in the Nez Perce tribe because that's where we live. That's where they can exercise treaty rights. And that was a decision that we as a family made. But I can see a situation where both tribes would say, we want that child to be here so we can provide those teachings.
Right. So I'll pause there and say, any questions on determining which tribe is the child's tribe? Okay, I think as lawyers here, our practice obligation is simply to try and make sure that the record provides the information to the extent that we can, that the judge is going to need to resolve these kinds of issues. So, to the extent that we can do that, then we can get these determinations made on a fully blown record in a not rushed but in a timely fashion, so we can move the case forward and have the tribe, properly represented in the case. Okay. Next slide is about how ICWA applies to shelter care hearings, and I think this one is really a big one, and it's a very different approach. As I said earlier, before the adoption of the regulation in 2016, ICWA's application to the emergency portion of the child protection proceeding was really ambiguous. And we had, even in Idaho, despite our attempts to have unified practice, we didn't have unified practice about how we handled ICWA in shelter care hearings. So the reg makes clear that ICWA applies, and the statute really does make clear that ICWA applies in the emergency removal situation at the shelter care. The standard for an emergency removal is different than the main ICWA standard. So if a child is being removed and placed in shelter care, the ICWA and that child is an Indian child or eligible for possibly an Indian child, and I'll talk about that in a moment. The standard is that they can be placed in care to prevent imminent physical damage or harm. That's the emergency proceeding. If you don't meet that standard, then that Indian child should not be being removed under ICWA. That's a higher standard by a significant margin, I think, than the standard for placing a non-Indian child in shelter care. And the judge needs to be careful to make that finding. Lawyers going into the shelter care with the child who is or that they have reason to know might be an Indian child need to go in prepared to deal with this higher standard. The next thing is that ICWA provides that the emergency removal must be immediately terminated once the court possesses sufficient evidence to determine that the emergency has ended. This is another important piece here. When a child now goes into shelter care and they're not an Indian child, usually we are really wanting to be pretty careful about returning that child home. We want to make sure that the parent we're returning them to, whether it's a parent who has joint custody or whatever it is, that situation is safe for that child to be returned to. So, the judge is often going to proceed in a measured way before making that determination, and might, depending upon the facts and circumstances, decide to keep that child in care pending the adjudicatory, so a more full-fledged determination of the facts can be made, right? If there was grounds to remove the child in the first place, then the judge might be concerned, the prosecutor might be concerned about improvidently returning the child home if they don't have a full handle on the situation. Under ICWA, that sort of erring on the side of keeping the child in care pending the adjudicatory really would not be a permissible approach. And so the act, in addition to having the standard, requires that the state diligently investigate whether the emergency continues and promptly hold a hearing whenever new information is received or assertions are made that the emergency has ended. So these are unique provisions to ICWA that really govern the ability for that child to stay in shelter care pending the adjudicatory if the situation that brought the child into care is resolved. Even if we think that the child protection case might still be ongoing, but the situation that created the emergency that caused the child to be removed, if that is resolved, or no longer continues to be an emergency, even if it's still a problem, that child should be going home.
Yeah, a good example of that would be there's a lawsuit in South Dakota where the state is being sued because they're not properly applying this kind of thing. So these kind of regulations were drafted to address particular situations that were happening. So one example is, parents go out dancing and they leave their children with a babysitter. The babysitter starts drinking and driving and gets pulled over with the kids. The kids get removed. The parents are called while this is happening. The parents show up. The parents had been drinking. So at shelter care, they said, no, we're not going to place the kids with you. You've both been drinking. But once that's been resolved, the drinking issue was the reason that they were removed. Right. So once that's resolved, the parent should be able at that shelter care hearing to say, the issue has been resolved, I want my kids. In South Dakota, they were not allowing the parents to even say anything at the shelter care hearing, even if they showed up. So again, this was meant to address a very particular issue that was happening at the time.
So, okay, and then the other thing about the ICWA emergency removal that's clarified by the regs is that, the emergency removal should not extend longer than 30 days. So if the case is going to be continued past 30 days, there has to be a hearing and a court determination that there's clear and convincing evidence that the child should remain in care, that custody with the parent would cause imminent physical damage or harm, or that there are extraordinary circumstances that justify keeping the child in care beyond 30 days. So the timing then becomes really important for that adjudicatory and not continuing that shelter care while that child is in care. And those requirements that the hearing only be continued after a court determination based on clear and convincing evidence, those are part of the reg regarding the emergency removal of children. And then finally, the reg makes clear that the ICWA 10/20 day notices are not required for emergency proceedings. So there are no unique ICWA notice requirements for the emergency proceeding. You only need to comply with the regular state notice requirements for a child protection proceeding at the time of the shelter care. ICWA does not impose any other additional rules. Having said that, though, I would recommend that if you know that that child is an Indian child and you know what tribe they're from, which a lot of times you will know. I mean, a lot of times you won't have the foggiest idea. But if you know, a call to the tribe to let them know about the shelter care hearing would probably be an extremely helpful thing in helping move the case forward and getting compliance with ICWA in a speedy way and appropriate way. So I know the shelter cares come fast and furious, but if that's possible, it certainly would be best practice to do if you know. Sometimes the kid, you're familiar, the department's familiar with this kid. They've been trying to do, truly voluntary plans. They haven't initiated a CP case. They know the kid, they know the kid's family, they know they're an Indian child, and we can just get going and get the tribe involved from day one, and that's gonna increase the resources available for that tribe in almost all circumstances. Yeah, so questions on the ICWA provisions with regard to shelter care hearings and emergency removals?
I have a question.
Sure.
This is Galen Carlson. First of all, is there any case law that helps a court define when an emergency has ended? What an emergency is, because it's very vague, open essentially to interpretation.
Yeah, I hear you, Galen. I think there will be case law developing, but I don't know of any on that particular point at the moment. There is a growing body of case law on some of the other pieces of the regs, but on this one, I don't know. So I think you just have to refer to that standard. An emergency is a situation where you've got to bring the child into care to prevent imminent physical damage or harm to the child. That's the standard for an emergency under the Act. But I agree with you, even that standard, how imminent does imminent have to be? there's all kinds of situations where there are threats out there. There's something going on that we would consider to be neglect, but it is really threatening physical damage or harm to the child, and is that enough? And I think we're just going to have to see how this develops. But I do think there will be some case law. I just don't know of any at the moment.
Thank you. As a follow-up question, then, should our court be expecting the parties in the case, no matter whether it's a child attorney, parent attorney, prosecutor, or guardian ad litem attorney, that when or if any one of those parties believes that the emergency has ended, that the court should be making itself available promptly, whatever that means, prior to the adjudicatory?
Yes, I do think that the courts need to expect that, upon a request from one of the parties to determine that the emergency has ended, I think the court's got to schedule a hearing under ICWA. I think that's exactly what it means.
And so is the anticipation then that the parties would need to be could potentially hold an adjudicatory hearing much quicker than the 30 days that the state law requires? Essentially, if, for example, a public defender or a child attorney believes that the emergency has ended and gets a hearing prior to the 30-day adjudicatory hearing, that the argument, essentially the fact that would support the emergency having ended, could potentially be the same as the adjudicatory evidence.
I think they could potentially be, and that might be a possibility, but I'm not sure how often that will happen. I mean, the emergency may have ended, but the parent may still have some really difficult things going on that cause us to say, okay, under this ICWA standard, we're going to go ahead and let the kid go home, but there's still a CP case here. Number one. Then number two, I think you want to be careful about due process with the parents' rights and making sure that they are, prepared to address all the issues that might come up on the adjudicatory, which may be broader than the issues that would come up in determining whether the emergency has ended. Having said all of that, I could see that there are plenty of cases where determining whether the emergency has ended is pretty coextensive with the adjudicatory findings that are going to be needed, and they might be combined together. So I don't think the Act is assuming that that would be the approach. Does that make sense?
Yes, it does. And I'm sorry to have so many questions, but just in terms of interpreting then, does an emergency removal being terminated once the court determines that emergency has ended does not necessarily mean that the CP case should close?
No. That's kind of embodied in my point, that the emergency removal is kind of a separate thing under ICWA from the child custody proceedings. So you may still be going forward with that child custody proceeding and go to the adjudicatory, and the result of that adjudicatory may be that child is placed in foster care. And you are able to make the findings that you are required to make under ICWA, and you're going to go ahead and make a hopefully ICWA compliant placement for that child. The emergency removal is just about that initial period of time when that child has been removed from shelter care to adjudicatory, but not about the larger CP case necessarily.
So for an example, I would use that South Dakota case. You had the babysitter that had been drinking, you had the parents who had been drinking. Once the shelter care was being held and parents show up and they're not drinking, to me, that emergency has gone away and the child should be returned to the parents. Then if there are issues beyond that, like maybe they have a drinking problem, then that investigation, assessment, or whatever can be done during that time. You don't necessarily have to dismiss the child protection case.
Right.
So is it fair to say that the emergency removal has to do more with placement where the child should live during the time frame between removal and adjudicatory?
Yes, it does. Placement in the sense of placement not with the parents. You know, if between that shelter care and adjudicatory that child's not going to be with the parents, then that's what emergency removal is about. It's really, I think it's really, one of the reasons why Julie and I go over the history is it's really important to think about what ICWA was trying to do on this. And one of the things that states had been doing that to bring children into care is they would have this emergency. You know, they would find the child playing outside, you know, without supervision, and maybe the parent who was home had was drinking or I don't know, and they would remove the child, and there would be no findings or anything like that. And by the time we got to the adjudicatory pre-ICWA, that child was placed for adoption already, and the parents would show up. You know, and it maybe was a babysitter who was watching them, and the parent may have been not exercising the best parenting skills, but all of a sudden their child's adopted. So the purpose of ICWA was and this emergency removal is to really ensure that we're not going to take that child unless the child's in danger, and we're not going to be, you know, doing anything permanent until we make the child custody proceeding determinations. So I think that's trying to make emergency removals not be a lever for getting to the result of improvidently removing Indian children from their family and their tribe is what was, I think, is the goal here. So, you know, those are really good questions. Do you have more? Are there other questions? I personally think this emergency removal clarification is the biggest change in the reg that would impact us. There are other changes in the regs too, but I think in some large measure, at least in our bench guide and our bench cards and things like that, the best practices that we have been recommending are consistent with what the regs were doing, and so our practice is similar, but I think this is a huge one that's different. So other questions?
Could create additional hearings, like you said. It could prior to the 30 or 60 day mark. So.
Okay, the next slide is about, I just kind of fold a couple of things in here. How does ICWA apply to consent to foster care or TPR? So it's very clear from ICWA, and more clear now after the regs, that ICWA doesn't apply to what ICWA defines as a voluntary proceeding. And the ICWA definition of a voluntary proceeding is a situation where the parent can demand the return of the child and get the child back. If the parent can't do that, then it's not voluntary under ICWA, no matter what we call it under state law. So when a parent stipulates or consents, stipulates to kid going into foster care or signs the consents for the termination of parental rights, those are not voluntary proceedings under the Indian Child Welfare Act. And the provisions, there are special provisions under the Act for taking those consents. It has to be executed in writing, recorded before a judge. In the TPR instance, that's not so different. In the stipulation for foster care, I think that is different than we have normally done. The judge must certify that the terms and conditions of the consent or the stipulation were fully explained in detail in English and were interpreted in a language the parent understood. So that requirement is part of the regs, and the court, prior to accepting the consent, must require the participants to state on the record whether the child is an Indian child or whether there is reason to believe that the child is an Indian child. I want to underscore a couple things. I'm going to get to the determination, some more detail on the determination of whether the child is an Indian child. In general, we have some confusion on this in Idaho. And it's just gotten more confusing, actually. So in general, ICWA is triggered when you have reason to know that the child is an Indian child. The standard under the regulations is reason to know. That's a lot more concrete standard than we have previously operated under. We've previously operated under a reason to believe standard most of the time. I think the drafters of the act wanted to give the judge a little bit more of a bright line for what happens when it should treat the case like an ICWA case. So the regs provide that if you have reason to know that the child is an Indian child, then you have to treat the child as an Indian child till you discover differently. The case is ICWA if you have reason to know. The confusion comes in two places. First of all, there's one place in ICWA where they don't use the reason to know standard. They use the old reason to believe standard, and it is this situation that's on the slide now, where the court is taking the consent of the parties for a voluntary stipulation or for a consent to TPR. Here, when the parties to the case affirm on the record about whether the child is an Indian child, they are affirming under a reason to believe standard, under the old broad standard. I think the reasoning is that the court doesn't want to use these kinds of, the drafters of the statute, excuse me, didn't want these stipulations to be a vehicle by which we kind of levered the case out of the court without making the ICWA determinations and thwarted the act that way. So if there's reason to believe that the child's an Indian child, then the court in a consent situation has to ensure that the tribe has been notified, that the department has taken steps to verify the child's status, which requires inquiry to the tribes and those kinds of things. So this is the one place in ICWA, the only place in ICWA post 2016 where that reason to believe standard exists. Here's the second bit of confusion, and that is shortly before the regs were adopted, we went to the Idaho legislature here in Idaho and incorporated the reason to believe standard under which we had previously been working into our state statute. So Idaho Code 1616-19, the adjudicatory hearing, provisions regarding Indian children incorporate the reason to believe standard in our statutory language. And the determination was made this last time around because of opposition from some of the tribes not to seek a change in our statutory language to the reason to know standard. So right now, our statute says reason to believe, but ICWA says reason to know. And we're still discussing in the Child Protection Committee what recommendations we're going to be making for practice. But I think what we are likely to recommend is that courts be prepared to make both findings. If there's enough evidence to make the reason to believe finding under our state statute, the court should make that finding and order the department to continue investigating until it can make the reason to know standard. It's a little bit confusing and not completely satisfactory, but I think, and we haven't worked out all the details of what that advice about how to cope with this is going to be, but that's the direction we're heading, I think. So a little bit of confusion, but at least on the consent to foster care and TPR, the standard that the parents and parties, including the department, have to be able to affirm to the court is that there's no reason to believe that the child is an Indian child. So I'm going to just stop here and say questions on consents to foster care or TPR. Okay, I'm not hearing any. I'm going to keep going. Okay, The notice to the child's tribe's parent and Indian custodian. The changes here aren't very radical. The regs provide a lot more detail about what should be in the notice. The notice requirement under federal law is triggered by the standard knows or has reason to know. This is the problem I was just discussing, right? So the reason to believe standard doesn't trigger ICWA under the federal law, except in that consent to TPR and voluntary placement. Otherwise, it's a reason to know standard, although the court, I think, has to make the reason to believe finding under our state statute. So I've noted on the slide, make sure you kind of are at peace with that difference. I'd say to be looking for some clarification from the Supreme Court's Child Protection Committee I don't know whether it will be in the form of a revision to the bench cards or the Odyssey forms or what exactly it will be. Probably come out in the new forms that are going to be part of Odyssey. The notification, one of the things I think we need to make clear is that we don't need to know who the child's tribe is, which tribe is the child's tribe before we do notice. We've reason to know that the child's an Indian child and we don't know which tribe. We just need to send notices to both tribes or all three or all four tribes, however many there are. That should help us resolve which tribe the child's a member of. Now, those tribes are in possession of information we may not have been able to get by this point in time, and so sending them the notice that the case has been filed and we need to get there, folks, is a way that we're going to kind of surface some of that information that we need to have to resolve the child's tribal residency. The regs clarify that notice can be by personal service or electronic service in addition to registered mail, return receipt requested. So they kind of provide a more flexible way to do notice. And then no foster care proceeding or termination of parental rights until at least 10 days after receipt of the notice by the parent. And they can request up to 20 additional days, right? So that's all new. That's not new. That's in the regs. But I think probably no. Are there questions about the notice? Okay. Just a little list about the contents of the notice. The regs are pretty specific about what needs to be in there. The name of the child, the tribal affiliation, the petitioner or other document initiating the action, the petitioner and attorney. The notice has to tell them that they've got a right to intervene. That has to go in the notice to both the parent and the Indian custodian. I left off the slide, and the tribe. The right to appointed counsel, right to additional time, location, address, and phone of the court, the right to transfer to tribal court, and the potential legal consequences of action. I think the right to transfer issue, I'll just make a little side note on it. I believe, is it final? That the Nez Perce tribe has gotten certified as a 4E. Are you done with it? Or
yeah, Alana, it's final.
Okay. With some of our tribes being certified as 4E eligible, I think you're going to see more motions to transfer children from those tribes to tribal court than we've seen in the past. You know, one of the main reasons why tribes and parents didn't seek transfer to tribal court previously is because if they went to tribal court, they didn't have 4E resources available to them, and those could be pretty darn important for helping that parent get that child returned home and helping the child. And so now with the tribal court being, and the tribe being 4E eligible, that negative consequence of transferring back to the tribal court isn't going to occur anymore. And I think you will start to see more motions to transfer to tribal court. So that's just my little side note, and congratulations to the Nez Perce tribe for, and to the Idaho Department of Health and Welfare, both for working hard on, I think, making that happen. Okay,
Liz?
yeah, go ahead.
Sorry, this is Brandell Whitworth with the Shoshone Bennett Tribe.
Oh, hey, Brandy, I didn't know you were there.
Brandell.
Hello.
Hello.
One of the things I want to note that we're seeing a lot of notices come in. If you go back to the notice slide, it talks about what should be in a notice. However, we've been getting notices recently that do not have mother or father's names on them at all, or grandparents if known, and it's really, it's basically almost impossible for a tribe to identify whether a child is an Indian child if they don't have mom or dad's name.
Yeah,
Or
isn't
even
it?
if it's an alleged father.
It's not in the petition, Brenda?
Sometimes it is not.
Huh.
Sometimes it's depending on the state where it comes
Okay.
from. We've actually had a notice come in from a state, and I couldn't off the top of my head tell you where it was at, but a recent one come in with no mother's name indicated no, we get them all the time without a father, but
Right.
there was not even a mother's name indicated on it. Even in the petition, it wasn't.
That's pretty important. And the other thing is, from the baby Veronica case, it needs to be spelled correctly.
Yeah, I mean, the consequences of not identifying this child as an Indian child are pretty significant. So those kinds of mistakes and the lack of information that means a tribe can't really respond, they don't really know who the kid is, are pretty serious. ICWA specifically provides that any kind of adoption that we do out of a case like that is void, not voidable, it's void. And so I think it's really kind of playing Russian roulette to not provide that information.
So I think best practice would be to just try to include as much information as you have about the child and the child's family, including parents, grandparents, or...
These are minimum requirements. The things on the slides are the minimum requirements, not what you could provide. The more you give the tribe, and hopefully, you know, maybe you've even contacted them by phone or by email in advance, just trying to figure out, you know, where this kid belongs. But yeah, thanks, Brandy.
Can I say something real quick? This is
Yeah.
Alana.
Hey.
Hey, Brendel, when you say that some of the notices you're receiving don't have the parent's name, are you seeing that primarily from out of state, or is that coming from our department? Yeah, all of the ones we've got without the mother's name on them are from out of state. Oh, okay.
That's reassuring.
No, Idaho notices for the most part are really, really good.
Good.
I mean, occasionally we have a question, but as long as there's an email address or a telephone number from a worker, it makes my life that much easier because we can pick up the phone and call and say, hey, even if we left this piece of information out and get that.
Yeah.
Yeah.
Okay, good, thanks.
May I, this is Evelyn again. I wasn't sure if, but I think that a point of clarification on the notice, it was kind of a big deal for my office, is that we don't have to send it by registered mail anymore necessarily.
Right.
We can go by mail with return receipt requested, which is so much easier for us.
Yeah, that was a good clarification and broadening up the notice thing that I think has just eliminated stuff that was a little bit of a pain in the neck and often forgotten because it's not how we have been doing our state court notices. So, yeah. Other questions or comments on the notice? Okay. One of the really big things that the regs did was provide a lot more detail about what constitutes active efforts to prevent the removal of an Indian child, one of the two main standards in ICWA. Really giving a lot of detail, and I think it's instructive to look at what got listed out in the regs. I've got it spread over 2 slides in terms of this active efforts, because I think it really gives you an idea of how the active efforts standard is different and a higher standard than the state/federal standard of reasonable efforts. And it was intended by the Act to be different and higher. And I'll say before I start on the list that I think this is hard for us because, you know, the social workers, the department, you all who work with these cases all the time, you really kind of develop a gut sense about what constitutes reasonable efforts and a commitment to, you know, operating under that standard for the protection of children. And now you're coming into these Indian child welfare cases and it feels like you're not giving this Indian child as much protection as you would give a non-Indian child. And so I think that it feels like it's backwards and inconsistent and makes the active efforts determination a hard thing for us. But I think what you've got to hold on when you're looking at this, what you've got to hold on to is this overwhelming value of retaining the child's connection to their tribe and their tribal culture. And the problem that we've had historically of having state courts who aren't part of that culture kind of judging that culture from afar and making determinations that were adverse to Indian families. So you've got to kind of have that Kool-Aid in your brain, I think, in order to really kind of start understanding the active efforts. But I just wanted to add that I think we have worked really hard on this in this state, but I do think this is a hard one. And it's hard for many, many people in the system who feel like it's a little bit upside down when they're really down in the weeds looking at that child. So the list in the regs includes conducting a comprehensive assessment of the circumstances of the child's family with a focus on safe reunification as the most desirable goal, identifying appropriate services and helping parents to overcome barriers, including actively assisting parents in obtaining such services. I'll say, I think one theme of these active efforts requirements from the statute is a much more aggressive provision regarding the responsibilities of the departments to help the parents. I think that's not as aggressively thematic in our reasonable efforts world, and so
that would be things like a bus ticket, or you know,
yeah.
if the service, if I live in Lapway and Lewiston and where the service is 20 minutes away, somehow to help that person make it to
Right.
Lewiston.
Right. So identifying, notifying, and inviting the tribe to participate in support services to the child's family in family team meetings, permanency planning, and placement issues. And I think this is true even though the tribe is not intervened formally in the case, but they're out there monitoring and trying to get them more involved will often be helpful. They will bring resources to the table if they feel welcomed at the table. Conducting and causing to be conducted diligent search for the child's extended family members, contacting, consulting with extended family members to provide family structure and support for the child and the parents. I think a lot of this stuff about kin care and extended family members is being incorporated into our social work practice under state law too, because we're realizing and research is establishing how important this contextual framework is for all children, not just tribal children, but here you're seeing it built specifically into this active efforts requirement in ICWA. Offering and employing all available and culturally appropriate family preservation strategies and facilitating the use of remedial and rehabilitative services provided by the child's tribe. So this means you've got to be familiar with those services that the tribe might have available and include them in your case, even though in a non-ICWA case, you might have looked at a different service provider that you've got more experience with, the department might have, that they've got more experience with to provide services for this child, but the child's an Indian child. Taking steps to keep siblings together whenever possible. Again, also a value that's been incorporated into our general practice, not just our ICWA practice. supporting regular visits with parents or the Indian custodian in the most natural setting possible, as well as trial home visits of the child during periods of removal, consistent with the need to ensure health, safety, and welfare of the child. On this one, I particularly want to emphasize the Indian custodians. This is a concept we've been mentioning, and we've mentioned it over and over again. It is, this Indian custodian is a party who's not a party under state law, but who is entitled to be a party under tribal law. And whether somebody is an Indian custodian is defined by tribal law, and it can be often defined by tribal custom and practice. That means it can be defined by unwritten tribal law. And some tribes have incorporated definitions of who an Indian custodian is into their tribal codes, but not every tribe, and I think most tribes haven't. But that auntie, that grandma, that uncle, those folks have formal standing in our ICWA case, and they may not have attempted to intervene as a party. The child may not have been removed from them, but they are folks who can be included in these supportive services. And we've got to be, listening to what the tribal folks are telling us and finding out who these folks are, because they're part of this kid's family in all likelihood and are going to be in a position to help move the case forward. Identifying community resources, including housing, financial, transportation, mental health, substance abuse, peer support services, etc., for the parents or the family, and helping and utilizing and accessing those services. Again, really part of this aggressive theme through the active efforts of affirmative reaching out and help to that family to ensure that they are getting on the bandwagon and accessing these services if at all possible. Monitoring progress and participation in the services, and we're doing that monitoring, remember, under the active efforts standard. So my own view is we're talking about maybe more aggressive monitoring of the situation than we would with a non-Indian child. Considering alternative ways to address the needs of the child's parents and families if optimum services do not exist or are not available. On this one, I think it's really important to be thinking about tribal practices that might be unique to the tribe. I think about an experiment that the Coeur d'Alene court did, and I know the Colville tribe's doing it, and maybe it's not that unique, but these are the two I know of, in juvenile and domestic violence cases, using tribal councils and sweat lodges and things like that as incorporating those ideas into how we're addressing the needs of the family. Those are resources that we have. I know, for example, up in the Colville tribe, they're doing stuff which, as a DV, teacher of domestic violence in the law, it scares the living pee out of me. But I think they're bringing the abuser and the victim together in these kinds of conciliatory tribal elders meetings. But what they're finding is they're significantly reducing the cases that are coming into the DV, and they're significantly reducing reoffending. So these are really non-traditional remedies that are reflecting a different cultural set of values and understandings, and utilizing them can be part of our active efforts in our case.
I think that's an effort at, look, the community leaders want you to succeed, and we're there in the community, and we know what's going on, and we want to help you in any way we can. So the abuser.
So providing post-reunification services and monitoring also included in the active efforts to prevent removal. So that's a much more, we didn't have any guidance before the reg on what constituted active efforts. We just had some legislative history and the sense that active efforts were more than reasonable efforts. The reg has given us now a much more detailed sense of what was meant by active efforts. So any questions on that?
I have a question.
Sure.
Galen.
Hey, Galen.
Hi, should we be in terms of being culturally sensitive to, obviously, if we know of a tribe that is involved already, by the time of our case plan, the Department of Health and Welfare generally holds a family group decision-making meeting, and hopefully they've included the tribe in that meeting. But if they haven't, and we have the tribe on the phone, is there something that we should be asking for on our case plans that would incorporate tribal assistance or cultural things that we might not normally put on a case plan, such as just something specific that would be helpful for them within a tribe?
Yeah, I think that's an excellent idea because the tribe is a resource. Sometimes we have programs, you know, anger management or AA meetings, or, you know, that are more culturally appropriate. And sometimes those may be available and the social worker doesn't know that it's available. So yeah, certainly asking on the phone. And maybe Brandell, you can chime in here because you guys have some services too that maybe you can offer to IDHW.
Sorry, I just heard the end of your comment.
We were just talking about the how to incorporate tribally specific resources that are culturally relevant to the tribe, you know, and just kind of asking the tribe on the phone what kinds of unique services might the tribe have. That might be helpful.
Well, I can tell you that I would be willing to bet dollars to donuts that our mental health services on the reservation are probably more extensive than mental health services available off the reservation.
Yeah.
So, I mean, that's just an example where I think contacting your tribal partners ahead of time, you're going to be able to access a lot more, or at least a lot more quickly. Because I know we can get people into like 4-direction treatment for drug and alcohol evaluation usually a little bit faster than we can get into state systems to get those evaluations done as well.
Yeah, that's a good point also. So
Emailing or contacting, you know, even, you know, calling and saying, who do I need to talk to? For our tribe at least, well, I'm the attorney, we actually do have a case manager from Tribal Social Services that's assigned to every ISB case as well that can help coordinate those tribal services from our side.
sorry, I'm struggling with a cold up here too, so sorry I'm honking in the speaker. Okay, any other questions on active efforts? Okay, I just wanted to remind us all about the core ICWA finding. I don't think the regs give a little bit of guidance on this. I think our practice is fairly consistent with what the regs say. The core ICWA finding is that the child has been subjected to serious emotional damage or harm. In general, under ICWA, just reminding you that unfitness, abandonment, unstable home environment, which could be grounds for removal under various state laws, unstable home environment and abandonment are grounds under Idaho law. They are not grounds for removal of the child under ICWA because the child must be in danger. Now, you know, you might have some danger with that, but you can't just presume danger from the unstable home environment and think that that's enough. You've got to have serious emotional or physical damage is the finding that has to be made. Key facts that have been abused historically to place Indian children in care are finding that the child needs to go into care because the child has been left in the care of relatives. that the child is receiving traditional tribal medical care and not more mainstream medical care, that the child is receiving a non-traditional tribal education and not going to school. These are examples of kinds of facts that prior to the adoption of ICWA were considered grounds to remove the child from the child's home, and the requirement of serious emotional damage, emotional or physical damage was drafted to make it so that you were not removing a child for these reasons. Then the regs also make clear that community or family poverty, crowded or inadequate housing, alcohol abuse, or non-conforming social behavior are not enough evidence to meet the clear and convincing evidence of serious emotional or physical damage standard. So I think that there's not much new in Dodge there. The regs don't change what our understandings were as much previously on this. They really provide us a lot of guidance on active efforts. So questions on the serious emotional or physical damage? Okay, I want to make sure we've got time to talk about Burkine. That serious emotional or physical damage has to be proved with the testimony of a qualified expert witness. And the regs do provide some better guidance on who can be a QEW. The best thing is a member of the child's tribe who's recognized by the tribal community as knowledgeable in tribal customs related to the family organization and child rearing, or a person with substantial experience in the delivery of child and family services to Indians and extensive knowledge of the prevailing social and cultural conditions and the child rearing practices within the Indian child's tribe. Remember when I first got involved with ICWA in the state, the department had one QEW on staff for everything, and that's clearly impermissible. We don't do that anymore, thankfully. I think the QEW is the heart and soul of ICWA in a lot of ways, because it is the testimony of this person that puts the tribal context on the record for the court. And so I think it's important to make sure that you've got a good QEW. I also think it's important to understand how hard it is for tribal people to serve as the QEW. And so when you're having trouble finding one, it's not that they don't care. It's that you're asking a member of the tribe to come into usually state court and testify in support of the state about why the child should be removed from the child's tribal family. And, you know, that's a hard position for a member of the tribe to be in. So, you know, kind of keeping in mind that sensitivity, but also being really diligent in trying to line up QEWs. I know that many tribes are working hard to identify and train people to serve as QEWs for children from their tribe. And so hopefully that will help us fill this gap to make sure that we've got a good qualified expert witness. So, any question on the QEWs?
I have one, just to land.
Sure.
One of the scenarios that we find ourselves in frequently is at the adjudicatory hearing when we're trying to put on a QEW, and it is not an Idaho tribe. When Idaho tribe, we have not had issues, but you know, it's a tribe from North Dakota or Alaska or whatever, and we have had difficulty getting the tribe to communicate with us to provide a QEW. And so yes, it is a no-no. We don't use the social workers from the department anymore. But what do you recommend in a situation where we have to put on QEW testimony, but the tribe is not communicating with us? They have, you know, filed something where they're intervening, so we do have to deal with it. But we just can't get them to either assist us. I mean, we've had situations where we did get a QEW, but then they were never able to answer the phone during the hearing, or the voice got locked in school. But sometimes it's even just, they won't even give us a name.
Yeah.
What would be your recommendation in those situations?
I think sometimes you're just going to end up with a QEW who is further afield from that tribe than you would want them to be. Hopefully that person is a person who's going to be willing to reach out to the tribe as the QEW and maybe make a connection with the tribe and do some research on the tribe so that they at least have as much knowledge as is possible. But that is a serious problem, and there are not good solutions under the Act. The other thing I would say is that you want to really make sure that you have documented the efforts that you've undertaken to find a QEW in your case. But it is a problem. It's not that, I don't think it's that they don't care, especially get up to those Alaska Native villages and stuff like that, and they're tiny. And that they don't really have anybody. And now this court from out of state, the person they have has to be on the phone and talk to strangers who are thousands of miles away, and it's just, but it is a problem. I think you may well end up, asking somebody who's been a QEW for one of your regional tribes that you know better, whether they'd be willing to take it on, and would they have the time to, make a call up to this tribe and try to do some research and make contact so that they can offer the best testimony that they can for that child. I don't have other suggestions than that. And then document what you did. So, yeah. Other questions?
This is Brendel.
Yeah.
I thought that, well, in the past, the state of Idaho has done QEW training, and I thought that there was a list compiled of individuals who had been through the QEW training and were certified through the Department of Health and Welfare. So if push comes to shove, I think you can utilize people off of that list and ask them to try and contact the tribe to become familiar with issues that might arise in the case.
Yeah, agreed. That's a good suggestion. Okay. My last slide on the substance of ICWA, and we'll maybe get a little bit of time to just talk about the Brekeen case, with this currently pending attack on ICWA, is this with regard to good cause to deviate from the foster care placement preferences. The regs are very specific on this finding of good cause, and this is a point. There is case law out there. There's quite a bit of it, actually, both from prior to the regs, and there's several cases since the 2016 reg that are reported, none in Idaho, but a number in different places relatively close to us. So the reasons for the request to deviate must be stated orally on the record. The court has to find good cause in writing by clear and convincing evidence. And then the requirements. The request to deviate from the standards must either come from the parent, from the child. These are the reasons you can deviate: to further sibling attachment, to meet the, quote, extraordinary physical and mental or emotional needs of the child that are unavailable otherwise from a compliant placement, and the unavailability of a suitable placement after a diligent search. And I have really truncated that diligent search section to get it on the slide. So if that's the reason you're going to be using, you should make sure you're looking at the slide, at the act, because it defines the diligence of the search and gives some guidance as to what it must be. Deviating from the placement preferences is a pretty big deal, and the clear and convincing evidence standard was clarified in the regs that that's what you have to meet to make the finding, and then this is the list of reasons that you can base the finding on. Questions about deviating from the placement preferences? Okay.
Brekeen.
So Julie's going to pipe in here more. There are several arguments that are made in this case. It's filed in Texas. It was first started out as Brekeen versus Zinke, but since he is now no longer the Secretary of the Interior, it's now Brekeen versus Bernhardt. The first argument that's being made in the case is an equal protection argument. The idea is that ICWA is an impermissible racial classification under the Equal Protection Clause, and that the child status as an Indian child is a racial status, and that ICWA therefore is impermissible because it treats Indian children differently than other children based on race. This is the ground that the court decided the case on, and I think if you look at the authority, I don't know what to make of it. I'm not the hardcore Indian law expert, but the U.S. Supreme Court has pretty consistently recognized that membership in a tribe is a citizenship question. It's not a race question, that the tribe defines their citizenship. It may or may not be defined on race. A little footnote that is that the definitions of tribal membership based on blood quantum really originate under pressure from the federal government for tribes to come up with more specific standards about how to define citizenship. They are not how tribal people would define tribal citizenship for the most part. And the court has recognized that more recently. So the court has held that tribal classifications are not racial classifications and do not violate the Equal Protection Clause. So I don't know how much this will get. I'll let Julie.
Well, I think it's interesting that the parties did not even mention the Morton v. Mancari U.S. Supreme Court case that stands for this principle that tribal membership is a question of citizenship. It's a political status, not a racial classification. So really, it has implications beyond ICWA.
Yeah, I think many tribal people, as I point out on the slide, see the idea of ignoring tribal citizenship in favor of some sort of lineage or blood quantum race-based classification as really an attempt to just sort of go back to U.S. policy about eliminating tribes. It really is that kind of big of a deal, that ground. So. This slide is not showing up very well. Sorry about that.
Liz?
Yeah.
Liz, if I might, this is Brandell again.
Go for it.
And I think we need to also be cognizant that every tribe does not use a blood quantum.
Right.
Very many tribes does not have a blood quantum at all.
Yeah.
It's not in our constitution. So clearly, I think, the race-based arguments are going to be much more difficult when you've got tribes that don't use a blood degree to define their membership.
Right. Now, I'm really sorry. I didn't realize how badly this slide would look. The second claim that's made in the case is a non-delegation claim. And here, this one, I had to go get a little bit of an administrative law lecture from Rich Seaman, who some of you know. The idea is that Congress has impermissibly delegated its congressional decision-making power to tribes. And the place in the act where they're saying that happened is that the ICWA permits the tribes to enact a tribal code that has different placement preferences than the statute does. And if the tribe has done that, then the tribal placement preferences govern. The decision is, the trial court decision in Brackeen is based on a couple of old Depression-era cases that are of questionable ongoing validity, early administrative law cases. More recently, the U.S. Supreme Court has said that Congress can do these kind of delegations as long as it's provided the administrative agency, or in this case, the tribes, an intelligible principle on which its decisions must be based. I think that's a really loose standard, and the court has not struck down a delegation by Congress in over 50 years. So this is really dredging up an old argument, and nobody really knows whether it'll have legs or not. Then the last ground in Brekeen is a 10th Amendment anti-commandeering argument that ICWA infringes state sovereignty over child custody matters, forcing states to perform federal regulatory functions in violation of the 10th Amendment. This one I think is problematical because it kind of ignores the plenary power of the plenary federal power over tribes. Which coexists with the Article 1 stuff. So anyway, go ahead, yeah. I thought I heard somebody asking a question, did I?
No, that was Alana, I called.
Oh, sorry, that's okay. Again, here, I think Congress clearly, the federal government has the plenary power, and it's hard to see the 10th Amendment limitation, but again, very little case law. This is a fairly new theory, but this is another theory in the case. And then the final theory, I think, of the major arguments that are presented in the case is an agency rulemaking theory under the Federal Administrative Procedures Act, arguing that the 2016 ICWA regulation violates the APA because it exceeds the scope of the BIA's authority, the idea is that the underlying provision of the reg is, of the statute was unambiguous. I think clearly this is not the case. Just think about the emergency proceeding rule. The statute did not unambiguously apply, was not able to be applied easily to state law. It's taken this regulatory interpretation to give us good guidance on how to deal with removals in an emergency situation. So they're specifically focusing on the good cause to deviate from the placement preferences and arguing that good cause is an inherently open standard subject to different interpretations. So I think, I don't know, I think this agency rulemaking argument is on shaky grounds also. So those are the main arguments in Brekeen. Now, Julie might want to add a couple. We have like 2 minutes.
The 2 minutes that I wanted to use, Alana, are you still there?
I am.
Okay, I just wanted to use these 2 minutes. I just want to say that Liz has been a good friend for many years. She's also been a good friend to the Child Protection Committee that's tried to set standards for Indian children in Idaho. And I just want to acknowledge that all her years of service on that committee, and then her friendship with me and the tribes, and her participation as a board member on the ACLU National Board. I think she cares, she definitely cares about disenfranchised people, and that comes across. And I just have a gift that I want to present to her before we sign off. And she didn't know this.
I didn't know anything.
I'm sorry, Liz, my agreement was I was not going to do anything to get you choked up. So.
That's okay.
So we got a blanket. I got a blanket for Liz because it's in our culture. It's you gift to people that are that have provided you with gift in life, and she's, as far as I'm concerned, a friend for life. So
I would give you a hug, but I'm a factory.
No hugs.
I will say to all of you at this meeting that the greatest privilege of my career here has been to be able to work with the court and with all of you. I go to meetings of law professors and they're all looking at me like, how the heck did you get on the courts committee? They won't let us anywhere near it. And it has just been, I learn something new every day. I think everything I know about ICWA I learned from Julie and Brandel, whether they know it or not, and everything else I know about child protection and how it works in the real world, which I think I don't always know, is from all of you, and the ability to just really be engaged with all of you. So I can't tell you what an honor it's been, and how proud I am of our state and the passionate work that we're all trying to do to get this all right. I love going to tell people I'm from Idaho, and we're way ahead of these other places on
Yeah.
these kinds of issues and how we think about them. Not that we get it right all the time, but we're working hard on it, and that's just such a privilege. So thank you. This retirement thing is hard. So anyway, thank you, all of you. I wish I could see your faces. Thanks. Wow.
So, we actually have it scheduled until 2:30, so
Oh.
we've got plenty of time for questions, discussions. You guys were so efficient, you got finished early, so.
We thought we were until 1. I'm gonna just go, I'm listening, I'm gonna go to the door. There may be some students coming in to use this room for a study period, but I think we'll be okay. But I'm just gonna go check and see if they're there, but I'm listening.
Okay, I don't know if we wanted to open it up for questions or, concerns, issues.
Are you, okay.
You know, it's Friday afternoon. Liz is looking for students. There aren't going to be any students here. This is the last day of classes. There's nobody. They're gone.
Not kind of boring. We'll switch places. Thanks.
Oh, she actually,
Sorry.
there was a student out there.
Yeah, we're okay. They're not here yet, so.
Oh, yeah, they're not here.
So.
I have a sneaking suspicion they aren't coming back.
No, I think that they will be. Oh, but they're gone?
No.
Oh, okay. So questions on anything that we covered, maybe even Burkeen, since we wailed through that so quickly.
Can you tell us what's happening in South Dakota?
I think the parties are,
Yeah.
aren't they working on a settlement?
They have a mandatory conciliation, court-ordered mandatory conciliation process going on right now. I haven't seen anything out of it in Turtle Talk, and so I don't know that they've made any announcements. I do think it looks like they might settle the case, though, but maybe that's a little bit too premature. I think they thought they were going to settle it previously a number of different times.
Yeah, that's true.
So, but, so yeah, I don't have any new developments for what's going on in South Dakota. You know, and Burkeen just got argued to the Fifth Circuit, and the Fifth Circuit has not issued an opinion yet. Burkeen was decided by the same judge who declared the Affordable Care Act unconstitutional also. So, you know, I just don't know what'll happen there, what the Fifth Circuit's going to say about that case. It's getting an awful lot of publicity. It keeps kind of popping up. I don't know if any of you are watching, but articles keep popping up about this big attack on ICWA in the Washington Post and the New York Times. And I'm kind of thinking, why are they covering that? Because there hasn't been anything new that has happened. But
Well, I think the Goldwater Institute has a deep pockets, and they have public relations people, and they're out there trying to do what they can to overturn ICWA. And, you know, they found a judge in Texas that was willing to take the case and find in their favor, but I'm hoping that, you know, that all these years of and these principles of Indian law will stand.
yeah, I think I'm a, you know, mainly a family law person, and I would say kind of looking into Burkeen, it would take a major, a truly major revolution in Supreme Court authority and abandonment of Supreme Court case law for the court, if it were to ever get up to the Supreme Court, for the court to overturn ICWA. So I think it's very much, you know, an effort that's kind of in trying to sway people's thinking and lay the groundwork for something down the road. But I don't expect that ICWA's going anywhere in the near future as a result of this case, but it'll just be interesting to watch.
Julie, Julie, this is Elena. Do you know what the ultimate number was of states that signed off on the amicus brief on behalf of the tribe?
Yeah, I had that here somewhere.
21 states.
21 state attorney generals, the Casey Family Programs, and 30 child welfare organizations. There's a group of constitutional law professors that filed pro-EQUA briefs. There are members of Congress that joined in a pro-EQUA brief. NCAI and 325 tribal governments and 57 tribal organizations signed a brief. There's a group of Native American women that signed a supportive brief. The anti-ICWA folks included the Christian Alliance, the Project Fair Representation, the Goldwater Cato Institutes, and the state of Ohio.
Yeah, I know.
This is Gail again. Could you either Brandel or Julie or both let us know what we are doing well with ICWA or what opportunities we have for improvement? I mean, you've got a good audience here to give us some feedback.
Brandel?
This is Brandel. Love that you fun. I will say that for the most part, well, just as a point of, I guess, reference, I've been doing Indian child welfare work for 19 years now. I've been in-house counsel for the Shoshone tribes for 19 years. Just a couple weeks ago, I hit my anniversary. So I can tell you that the work we're doing now in ICWA in the state of Idaho is vastly improved. I think always the hardest part of ICWA work is early identification of kids. Because if you can get a kid identified at the front end, you're going to save everybody a massive amount of work in the back end. It is the hardest. I can tell you, Idaho's doing a good job of it. Obviously, everybody can always do better, I think, with identification. Because if you come into ICWA seeking compliance, you know, for the most part, you're going to comply. Obviously, there's hurdles, and I think just a recognition that some tribes, if you haven't ever worked in a tribal system, a lot of times what you find in tribal agencies is, you know, one person wearing 5 different hats with 3 different titles. And so you're not going to get an immediate response from a lot of tribes. Sometimes it takes sending emails and calling somebody to get their attention to take a look at your notices and give you an answer. But I can tell you that the room that I see to improve is at the front end. Identification of children, identification of family, concurrent planning. I think those are the areas where I think we can always improve. But I can tell you it is drastically better than it was, you know, in 1999 when I started doing this.
The differences are amazing, just, you know, kind of as a 10,000-foot observer, I think, from 1999.
Well, in the late 1980s too, Idaho got sued because they were not implementing ICWA in a good way. And I think instead of fighting that and really pushing back, Idaho said, you know, really it's federal law. We're required to comply with it, and let's just get on board and comply with it. And I think over the years they have gotten better. This whole Idaho Supreme Court Child Protection Committee, I think, is an excellent vehicle for ensuring that judges know about ICWA and that practitioners know about ICWA, and that it's the law of the land, so to speak.
I can tell you also that there are no stupid questions. If you have a question, ask it.
Yeah.
If you need to know something from the tribe, ask it. In ICWA, there are no stupid questions.
Yeah.
So, you know, if you have a question or a concern or just an inquiry, you know, we're here. That's what we do. So, and I don't know if it was mentioned, but I did want to also put on the record that Idaho did in fact join the amicus brief with California, and they were one of the 21 tribes that did actually sign the amicus in support of the Indian Child Welfare Act.
Yay, Idaho.
Yay, yeah.
Also on that, maybe it's a good place here for a plug for the Child Protection Manual. Even for practitioners, the bench cards are very helpful. I don't remember, Liz, maybe you recall which chapter it is off the top of your head, but there's an entire rewritten chapter devoted to ICWA and incorporating all of the regulations. And especially practitioners who don't deal with ICWA regularly, it's kind of hard to get proficient at using the regulations if you don't use them often. And so I found that being able to go back to the manual and refresh my memory or use the bench card if you're in an ICWA hearing is helpful.
I think it's chapter 11. It's woven throughout all the chapters, but then I think chapter 11 is specifically just an ICWA case from beginning to end.
By the way, Galen, thank you for asking that question.
Yeah. Other questions?
One thing we can do to try to get us just a few minutes later is I don't know if you guys announced at the beginning about emailing Dana for CLE credit, but I have the sign-in sheet in front of me. So if we could go through the people on the phone and give me names and bar numbers, I can sign them in so you don't have to look up for email address.
Yeah, there's nobody here.
Okay. And I have Carrie Wilson is on the phone and I have her bar number. Who else is still on the phone? Denise Frozen.
Mark
Denise
with
Frozen. Hang on a second. Denise, what's your bar number? 4163. Jennifer Bergen, I'm on the phone.
Oh, Jennifer.
Jennifer Bergen, okay. Jen, what's your bar number? 5050.
Sorry,
As opposed
Jen.
to 60-40.
Okay, next.
Lisa Nordstrom.
Oh, hi, Lisa, I'm under. Okay.
Hi, 5733.
Mark, did I hear you?
You did. 4254.
Okay, who else? Brandell?
She might have signed off already.
This is Brandell. I'm sorry, I went to unmute my phone and I turned it off on accident.
Do you want me to sign you in?
Yeah, my bar number is 6017. Thank you.
Anyone else?
This is when I just called back in, they said there were 8 people on the line.
1, 2, 3, 4, 5, 6. We would count to 7. Maybe with.
Somebody just, with Marie, just said something though.
This is Stephanie Ray.
Oh.
Stephanie, what's your bar number?
People remember the bar number.
9823.
9823.
Yeah.
So here's who I have that's on the phone. Terry, Wilden, Denise, Jennifer, Lisa, Mark, Randall, and Stephanie. Is that it?
You need to give ours.
You need to give yours. I'm on inactive status.
Oh, Liz is inactive, but my, Alana, mine is 4535.
Okay, we'll do that. We'll do yours here then, and we don't have to worry about your sign-in sheet that's there then.
Yeah,
Great.
okay, cool.
All right, anybody else? I thought I heard one more person. I think that is,
That's it.
I think that will do it. Oh, hang on just a second. Oh, I just got an email from Amy Long. She's our new JAG. She is watching the video but not on the phone.
Oh, okay. Yeah, that's the other thing, Alana, I'll email you. We've recorded the whole video and the sound, so I just will email you to find out who I should send the recording to.
If you'll just send it to me, Liz, then I'll get it to the right person over here at the bar.
Okay.
And I also, I sent you an email during the presentation asking for a copy of the PowerPoint.
Will do.
PDF and PowerPoint can be posted on our website for people either who didn't get to attend, who can watch it later, but also I think the PowerPoint's a great reference tool for us to have. So if you could just email that to me.
Will do. I would have done it in advance, but I didn't get it done in advance, so.
That's fine. Okay, so if there's anyone else that is on the, that's watching the video but not on the phone, if you want to get CLE credit, you'll need to email Dana at the State Bar, and I will give you her email address right now. It's E is in Dana. F is in Frank, ERRERO at ISB.Idaho, spelled out, .gov. And our next meeting is going to be May 24th. And I think we have Mike Elias speaking on representing guardian ad litem at it'll be our regular meeting. Thank you both, Julie and Professor Grant. I really appreciate you taking the time to do this for us. There you are.
Thanks.
Thanks, Alana.
It was really helpful. And Liz, I will talk to you before